Welcome back. And now let's head into the discussion on updates and developments on the contention of the presidential elections which held in February 2023. We'll be taking a look now at the updates on those cases, the Presidential Election Petition Tribunal. I've been joined now by Mr. Ehidiamen Destiny. He's a legal practitioner. He comes down to shed more light on the matter. Welcome to the program, Esquire. It's good to have you.
It's always a pleasure to be here.
Let's start with something we talked about the last time. You made, I believe, some predictions, and your predictions came out just as you said it would. That is the issue of live coverage.
Yes.
What can you really say about that? Especially bearing in mind that people keep saying that it seems there is actually no law against live coverage. I know one of the things in that ruling was that no law provides for it or something thereabout. But then again, is there a law that denies it or that says it cannot happen? Isn't it really at the end of the day up to the discretion of those presiding over the matter?
Okay, no problem. If you actually am pained, being a lawyer, I'm pained by that judgment. You understand? As a citizen. That's what I told you the last time. I'm pained by that judgment. Because that judgment would have enabled lawyers who cannot access the court. There are some lawyers in other states in Nigeria who will not be able to access the Supreme Court to learn from it. So we're actually paying, but law is not emotion. Law is not emotion. It is whatever in law is what we call legal, what is in the law. Now, there's no law expressly prohibiting it. There's no law and in support of it. You understand? But from the laws available, inferences can be drawn that justice will be put in jeopardy, in a precarious position, if it's televised. You understand? You have to understand it. Because the example I gave that time, there's a rationale for weaknesses out of court and act of hearing. These are evidential issues in the Evidence Act. By the time a witness giving testimony is being televised, his lawyer will be able to see the flaws in his co-witness testimony. There, he can be able to tutor his own weakness. Another lawyer tutor. He become a tainted weakness. On such, you are not getting the purest testimony from that weaknesses. That's number one thing. And again, you can look at the emotions of the public. People are likely to make heavy issues. There will be distraction. Lawyers will be coming, speaking. The matter will already become a matter which have already become subjudice. People will be devouring the matter. So I think these two things, it will likely to affect the evidence to be given, and two, the probability of it being misused and placing the weakness in a precarious position, because these weaknesses are going to be televised. You understand? Even there are some circumstances where people, locate a weakness to his house because of giving evidence against him. They may likely kill the person. We are putting the lives of judges, the lives of witnesses in danger. And again, why will you show the Supreme Court justices to the world, the Court of Appeal justices to the world? We are putting judges at risk. And again, the thing is not specific. How many media will come in? Of course, if one station come in, station B would like to come there, so you just turn the small vicinity of the Court of Appeal into a camera unit. That will be distraction. So I think that from the law, like the one I just said from the Evidence Act, which is I mostly relied on, that it does not support telecasting Court of Appeal presidential proceedings.
All right. Let me give a personal experience. I actually followed one popular American case last year, I believe, the case between the popular actor Johnny Depp and his ex-wife. In my opinion, I believe that because the court cases, the sessions became sort of entertainments to people. They were tuning in, every night, getting their popcorn is my daily dose of this case. People really enjoyed it, and a lot of YouTubers made millions just from analyzing and streaming it, and it was a whole thing. And a part of me always felt that the jurors who were, because they are told, just as you say, out of sight, out of hearing, apparently the jurors are told not to follow the social media or follow the and it was so popular that you have to wonder how possible is it that these persons were able to stay offline, stay off air, and not see any of this the narrative following it and all that, and they didn't taint their ruling or their judgment, their decision. I always wondered, like, it's very likely that they were swayed because there was commentary following all of these things.
Everything.
Yeah, so now, but the issue now is it still exists in America, in some African countries. How have they been able to, some of the issues you've raised now, how have they been able to, will I say supersede it or make it not important enough to stop live coverage? Okay. And what can Nigeria do to get there so that at the end of the day we can avoid some of these pitfalls? Okay.
Like the one you said now, it became of America interest from what they presented to this court, because in law, a case is decided based on the facts, peculiarity of facts of that case. America wanted to see the court proceeding leading to the conviction or possible conviction of the actor. They made an application. It was approved based on the peculiarity of the fact and also the law governing that state. In America, they operate different states have their own law. It's a pure form of federating state. But in Nigeria, there's no such. The only thing that we have here is visual hearing. If it is so demanding that it become irresistible not to deny, especially in trying times during the COVID-19. There was visual hearing, but that one is still regulated. You understand? Because they have to accept the people that will be able to sign into that visual. Is it the visual link created? They will see that both in this they say telecast. That word telecast, it means that to be televised, for the proceeding will be televised. But like I said, I'm a lawyer, I'm a citizen. Actually, I'm against it. It would have benefited me. But no law supports televising Nigeria election proceedings.
But can we get there, do you think?
If you tell your legislators and they put it in our law, in our statute book that the presidential election shall be televised, the court does not have the power to say they are not going to televise it. So if it is in the law, it is in the law.
Right, so I believe that's fair enough. Let's quickly move on to another issue, which is rearing its head or reconvening or happening again on the 26th, that's tomorrow, of May, wherein the issue of the alleged double nomination of the vice presidential candidate, or the vice president-elect, so to speak, of the APC, Senator Shettima, will be, finally put to rest in one way or the other. I don't know if you can help us with a little bit of background to this, because what people know is that there is presidential election petition going on. So there's a lot of Nigerians are surprised. How is there a case already in the Supreme Court that still sort of relates to this? And then the second question, what is the implication of whatever could happen tomorrow?
Okay. Let me give a little bit of background. What actually happened before APC conducted their presidential primary? They have already done the National Assembly primary election. You understand? So Shettima contested in Borno Central Senatorial District, and he was the APC candidate, APC senatorial flag bearer for Borno Central. Upon Bola Ahmed Tinubu winning APC presidential primary, the constitution mandates him to nominate a vice presidential candidate for them to run together. Two of them, they are like Siamese twins. before you can be qualified, you must nominate. That is what the Constitution says. You know. So Bola Ahmed Tinubu nominated Kashim Shettima, who had already been nominated as a Borno Central Senatorial District, as a Borno Central senator, for him to be contested as a senator. The question now is that APC first of all submitted names of Kashim Shettima to INEC before he was nominated as APC vice presidential candidate. Are you understanding me now? So the question then comes, the day APC wrote to INEC that this person has withdrawn from the senatorial race was also the day they submitted Kashim Shettima's name. It's like at that point APC submitted the name, he was still a candidate, senatorial candidate. Now the question under the session, they say if you allow yourself to be nominated for more than 2 constituencies, allow yourself to be nominated. That is the underlining word. When he wrote a letter to withdraw, did he allow himself? That's the question that the Supreme Court will resolve. Again, the most fundamental question is the issue of local standard. This is a pre-election matter. The only party that had a local standard, the right to challenge the nomination of another candidate, is the people who contested in that election, or people who contested in that election. In this case, PDP who are challenging the nomination of Kashim Shettima, are they members of APC? That is the most germane question. Do they have the local standard? Local standard bequeaths the jurisdiction of the court. Now, again, if you look at the timeline of judging pre-election matter, I think the timeline ended in February, in between the month of February. The timeline for the Supreme Court to decide it. In pre-election matter, 60 days from the date of conduct of the primary election, 180 days, 60 days at the Court of Appeal, 60 days at the Supreme Court. Now it's over 200 days. Supreme Court pre-election matter ended. Will the Supreme Court still go ahead and give decision when they have no jurisdiction? This is the question. This is the $1 million question before the Supreme Court tomorrow. I think they don't have jurisdiction. PDP don't have the local standard, and even on matter of merit, I don't even think that PDP can actually establish that Shettima had a noble donor. But on the other hand, the dangerous implication of Supreme Court disqualifying Kashim Shettima is that it will lead to constitutional crisis in the country. That may lead to instability. In fact, the country, because if Shettima is disqualified tomorrow, normally what the law says that the second person who scored to third of all the votes should be declared the winner. Now in this case, result as declared by INEC, apart from Senator Bola Ahmed Tinubu, no other person scored 25% in 25 states. And Buhari is going to vacate that office 29th May 2003. It will lead to constitutional crisis in Nigeria, and it may lead to instability, implosion in Nigeria. That's the dangerous implication of if the judgment goes against Asiwaju Bola Ahmed Tinubu or Kashim Shettima.
That is interesting, and it's a lot to handle. We'll see how that really turns out. Tomorrow is the day. But that aside, let's quickly touch on back to the presidential tribunal.
Okay.
Recently, something happened where I believe the courts, if you can correct me, suggested that the cases be, for lack of a better word, should I say joint, but not really so. Consolidated, that is the word, yeah. And I believe the APC initially tried to counter this or were against it. I'd like to know the implications. I would think that it makes the work easier for them, because if it's together and it's struck out, isn't that, just I'm trying to get your legal opinion. And does it mean once it's struck out, it means both cases are gone, or is it a case where you still have to take it one at a time? Why would the APC be objected to this?
APC, I think they don't want the three of them to join together and fight them. That's what APC are saying. So they are saying they are objecting to consolidation of the suit. Is to make it easier. But even at that, a matter which is being consolidated, it is still imperative on the judges, even by law, for them to give decision as regarding each party's case, even giving judgment on consolidation matters.
So what's the point of the consolidation, really?
It's to make it faster. It's just all of them, they are coming together. Instead of saying day one we hear you first, day two we hear you first. No, it is time wasting, energy sapping, and time consuming. I think it's allowed in the statutes, section 50 of the schedule attached to the Electoral Act. It's allowed for them to consolidate, for the judges to consolidate, and if the parties agreed to.
All right. There's a language a lot of lawyers use that I'm not sure I understand really. Jurisprudence, really. I think it's supposed to mean the subtotal of everything in.
It's like a scientific study of law.
That no. Yeah. So the other day we saw some. I don't want to call them protesters, but some persons at the appeal court, airing their views, and basically they are saying that all the decisions or whatever we're going to get during this period from the tribunal, Supreme Court, and all that will have significant impact in the jurisprudence overall, going forward and forever and so on. So I'd really like to know from you some key issues like 25% in FCT and so many other issues that are in contention at the moment.
Yes.
What would be the overall implication in the years to come in other cases, in other elections, other contestation of elections, and particularly in this new era of the BVAS? Okay. Will any of this have, or what kind of effect really can we expect it to have? All the decisions.
Okay. So one fantastic thing about election year is that it broadens the Nigeria jurisprudence. It adds more. Whether because there must be cases, it broadens the Nigeria jurisprudence. So in this case, with the enactment of the new Electoral Act, there are bound to be novel issues. So the ability of the courts to decide it means that issues has been solved. That's the implication. That means the Nigeria electoral jurisprudence has been enriched. You understand? By the court resolving this novel issue in this new Electoral Act. You understand me? Matters of BVAS, matters of double nomination, which was introduced by this Electoral Act. Matters of 25% in FCT, double nomination, and the use of BVAS. But like I can tell you, the Electoral Act is already being enriched by this single case of Oyetola and Adeleke. Yesterday, the CTC of the judgment was out. And I can tell you, it is even more Herculean for a petitioner to survive and win electoral matters. Because Supreme Court said that you must provide the BVAS machine, which means you must carry all the BVAS machine that was used in the polling units that you were disputing to the court to prove overvoting or electoral malpractice. Look at it. I will send everything if I will avail you. That's what the Supreme Court said. So people now who are the tribunal, if they are to win election petition, or the petitioner is to win, he must bring in the BVAS machine, tender it from the report of it, the registered voter, and speak to from ECA aid orally by witnesses for him. You see, these three things, they must coexist for you to win, for a petitioner to establish his case and win his case at the tribunal. Again, He also spoke on the probative value of back-end server, which is RF, that's INEC result putter, RF. But it is not a veritable means of proving over voting or electoral ringing. So those people who are heavily rely on to prevent report of IRF, it's just like they are chasing, chasing what we call whiff so the whiffs. But when you are going on the way, you see something like water. You think that if you go close, you can catch it. That's what they are doing now. They want to catch whiffs so the whiffs. They can't catch it. So now people now know that to prove overvoting and ringing, you need your BVAS machine, your BVAS report, the voters register, and the form EC, which is the building block of electoral litigation. That form, which I explained the other time, that form where they sign, they make entry of scored by candidate. That is the most important thing in election, in election petition matters, to prove ringing, overvoting by the petitioner. Do you understand? These three things now have to establish, it has been established. But furthermore, as we go in further, other issues that will come, this 25%, double nomination, what amounts to double nomination will also be resolved. That's the beauty of it.
All right. I do hope
the other time, in 2015, Jonathan never went to court. Some lawyers were angry because by you doing that, you are failing to broaden the electoral jurisprudence of Nigeria. And other lawyers said election time is the harvest time for lawyers.
That is
apologies to Robert Clark. He said election time is the harvest time for lawyer.
Yeah, that is interesting. I've seen that the other day there were rumors afloat of the average pay of a senior advocate of Nigeria, and I almost considered going back to school and studying law. But anyway, thank you so much for coming, and it's been a great time and an enlightening episode. Thanks for coming.
Thank you very much. It's a pleasure to be here. Thank you very much.
All right, that's all we can take now for this segment and this the program today. We'll leave you now with some updates, but don't forget to join us every weekdays 2 p.m. to 3:30 p.m. The Polity reaches you live from Abuja. Have a nice day. See you tomorrow. I am Amadin. Bye for now.